Good morning, everyone, and welcome to the 2012 Osgood Forum, the annual conference of the Graduate Law Students Association here at Osgood Law School. I'm very happy to welcome to our opening panel five very distinguished persons, which I would like to introduce. I'll start with Dean Camille Cameron. Camille is the Dean of Windsor University Law School. She was Professor of Law at the University of Melbourne and a founding member of the Advocacy Institute of Hong Kong. She was also practicing law for 10 years at Nova Scotia. Mr. Tom Conway is from the Law Society of Upper Canada. He was on the Licensing and Accreditation Task Force. He chaired the Federation Implementation Committee, and he's a partner in Cavan, Williams, Conway, and Baxter, and he's also in the Articling Task. He's the chair of the Articling Task Force of the Law Society. Miss Laurie Politza, which is the treasurer of the Law Society of Upper Canada. Treasurer Politza is a partner at Torkin Mannes in Toronto, and she's practicing family law. I just want to mention that all those people have a very long biography, and it's all on our website, and I'm just doing a short biography, so we'll have time to discuss the important things we're going to discuss. Dean Lawrence Sussin, Dean of Osgood Law School, whose areas of scholarly interest also include the regulation of the legal profession and the future of legal education. And finally, Professor Angela Swan, that I have taught at the University of Toronto from 1965 to 1988. She's been in practice from 1987. She taught at McGill University from 1996 to 2002, and she's an adjunct professor at Osgood Law School from 2003. The way we're going to conduct this panel is by three parts. We will start by me asking each keynote panelist a question, and this will be the first part. The second part, the keynote panelists will comment on their friends' words. And finally, we'll open the stage for questions and answers. I want to mention that we are video recording this session, and I think we can start. So I would like to start with Dean Cameron and ask you, based on your international experience, what do you think are the lessons for Canadian legal education that we can learn from other jurisdictions that you've been experienced with?
Thank you. I will confine my comments, given the time we have, to Australia. I think that makes sense in the circumstances. I will look at what's happened in Australia against the backdrop of what might happen in Ontario. As everyone knows, we have been talking in Ontario about certain articling changes. I'm not going to talk about those changes today. Many of you will know 5 options have been presented, and they've been mooted and are still being mooted. And we'll leave that conversation for another time and place. I am, though, just going to make a few comments on the assumption that there will be changes, and that those changes will see a different kind of approach to and philosophy about articling, a different kind of approach to and philosophy about transitional training. And I'm going to then ask some questions based on the Australian experience about what we might learn, what we might take to our discussions in Ontario and perhaps more broadly in Canada about legal education. And in particular, I'm going to focus on the connections between education in the academy and education for practice. And I will begin by saying the gist of my comments will be that there really shouldn't be that much of a separation in our attitudes and our discourse about training in the academy and training for practice. And so I think what we can learn from thinking about the Australian experience is this. As the approach to professional training changed in Australia, and let's go back to the 1970s, when articling was abolished in at least one state in the 1970s, it was done in a context where there was still, in my view, quite a sharp distinction in the language and the minds of people about what the academy was for and what professional training was for. And so when in the state of New South Wales, the decision was made quite some time ago, remarkably, 40 years ago, to abolish articling and to replace it with what was called, excuse me, a practical legal training course. That practical legal training course was really quite divorced from what was happening in the academy. And there was still perhaps an attitude towards education, that education happens in stages. And the first stage is the academic stage. This perhaps was influenced, I think, by the Ormrod report out of England, or at least the Ormrod report, perhaps I'll say it the other way, was a reflection of these attitudes of quite a line drawn in the minds of many and in the discourse between what happened in the academy and what transitional or professional training was all about. So then for some years in Australia after that, in New South Wales, they proceeded on the basis of that practical legal training course, but there was still quite a divide between what was going on in the academy and what was going on in the practical legal training course. The evolution there is what I think is interesting for our purposes, and the evolution was more or less like this. Then in New South Wales in the 1990s, a number of universities came on board with what they were calling practical legal training courses. That was quite a shift because it brought the universities into the practical training or transitional training scenario, landscape. So that was the first difference. But it also was quite easy for those law schools to get approval from the accrediting board to actually run these courses. And that's an indication of a broader shift that was happening. It's happened in Canada, I'll come to that in a moment, but it was also happening in Australia, where what was happening in the academy was changing, I think, as people realized the education of a lawyer doesn't necessarily happen in distinct stages. Okay, and instead there are not watertight compartments of what happens in the academy, where, to borrow the words of one commentator, you stay away from the mundane things that lawyers do and focus on theory and principle, and then you get to the mundane things that lawyers do after the academy. That thinking had changed. And so by the time those new law schools in New South Wales, Wollongong, Newcastle, and a few others came on board and had a relatively easy time, I think, getting accredited, law schools had already changed quite significantly from the 1970s. And so I think when we think about what might happen in Canada, in a sense, Australia is a good comparator, but in a sense maybe we have to be careful. And we have to be careful because the ground on which the changes that happen in Ontario, and you can see I'm assuming they will happen, and I'm pretty confident that they will. I'm just not entirely sure what they might be. But I'm
no
assuming,
one is.
Exactly, which is why I've stayed away from the topic today. I'm assuming they will happen. I'm assuming articling will look different. I'm assuming transitional training will look different. Okay, I'm proceeding on that assumption. But those changes, whatever they are going to fall on much more fertile and in fact different ground in Canada than they did in Australia, especially around the attitudes of what the academy is for and what transitional training is for. And all we need to do is look at what law schools in Canada are doing already compared to what law schools in Australia were doing in the 1970s. There's quite a difference. And so what is one significant feature that might come out of this? I suspect, therefore, that law schools will come on board as participants, active participants in the transitional or professional legal training scene in Ontario much more easily and quickly than they did in Australia. Why? Because we've already had the advantage of an evolution towards law schools that have clinical programs that think about the blending of theory and practice, that don't think about what lawyers do as mundane to be left for somewhere other than the academy. There has been a shift in attitude. I'm not trying to say that that is generally the attitude amongst all Canadian law schools, but I think we will see quite a different dynamic in Ontario post those changes than we did in Ontario. And one of the things I'm predicting is that there are some law schools, not all, who will come on board and be participants in the new practical legal training landscape much more quickly. I think I'll confine myself
Thank you,
to that.
thank you. So I want to address the next question to Tom. Tom, if you were a law school dean, how would your school be different from current Canadian law schools?
Well, I thought I had a pretty good answer to that, but having listened to Dean Cameron, I'm not sure anymore. You know, these are really exciting times, I think, for law schools and for law societies, because I mean, at least from my perspective, being involved with the Federation of Law Societies and implementing the task force recommendations of the National Task Force on the Common Law Degree, and, you know, working with deans and other members of the Academy on implementing those standards, and then chairing the Articling Task Force. I think when I started out on this sort of this journey that I've been on for the last couple of years, I was struck by the two solitudes that seem to have existed for almost from the time that Osgoode Hall left the grounds of Osgoode Hall downtown and struck out on its own. There had been a division between the Academy on the one hand and the law societies of the country on the other, with respect to, you know, they clearly defined their spheres of influence, their spheres of their jurisdictions, and although they claimed to be speaking to each other over the decades, I think that was rather a hollow dialogue. But I think with a new generation of academics, and particularly the deans that are leading the law schools, and certainly the new generation of benchers and others who regulate the profession, there has come to be a common realization that ultimately we have to, our two purposes is to, well, certainly from the regulator's perspective, is to provide competent lawyers for practice. That's not traditionally been the view of the Academy, and for good reasons. You know, I think in Canada, the law schools in Canada have traditionally viewed themselves as being academic institutions, that their role is not to train lawyers for practice. Their role is to provide an academic program of study, and graduates from that academic program of study can then go on and do many things, some of those things may include practicing law. From the Law Society's point of view, of course, we're interested in having graduates from law schools who apply to our licensing process to have some sound academic training or education in the types of subjects that they will require for practice. You know, and of course, what is required for practice now is very different from the traditional academic requirements of a generation ago. One thing I've learned as a bencher is that we are living in tumultuous times when it comes to the legal market. And we see regulators in the United Kingdom, in Ireland, in Australia, who have lost the right of self-regulation. The government is imposing regulation on the profession in those jurisdictions. And the discussion or the terminology has changed quite a bit. So instead of talking about the tradition, viewing the profession in the traditional ways we've done it as a profession of higher learning, and one in which you need a sound academic foundation, followed by a strong period of practical training, so on and so forth. Those approaches are now being replaced by the more economic model, if you will, or regulators in the United Kingdom, in Australia, and so on, are talking about legal services, the legal services market, the provision, the provision of providing the consumer of legal services with the products they need. So the language has changed dramatically. And indeed, I think in the next generation, we're going to see legal services being delivered in many different ways, probably ways we can't even imagine now, and quite probably not by lawyers. I mean, I think you're seeing it now. Basic wills, for example, are, there's a pretty good argument to be made that a software program can probably produce a better will for the average consumer of legal services than a solicitor can. So we're living in that environment. So if I was the dean of a law school, to answer your question, I would be looking at the legal landscape in Canada right now, and I'd be saying to myself, okay, the law schools in Canada at the moment do an excellent job in the traditional model of providing academic training to students, and that's great. But there has been a disconnect between what the law schools do and what practice looks like, and the graduates of the law schools typically have come into our licensing processes and come to the practice of law very ill-equipped to cope with the practice of law. So if I were a dean designing a law school, and I know I know the deans on the panel are going to say I'm extremely naive in saying some of these things, but if I was to do it from scratch, I would be thinking very long and hard about providing an academic setting, a setting in which lawyers would get the sound academic training they need. I don't think it needs to be 3 years for the average consumer of legal services. I think lawyers these days are going to have to know as much about software programs and marketing services and providing a product or a package of products for the consumers of legal services. And that is a very different approach. So I would be incorporating into the curriculum practice management skills. And I would build a law school in which we could say, our graduates are practice ready. And I know that that's not the role for every law school. There are always going to be the law schools in Canada that will produce, the top constitutional litigation lawyers and the jurists and so on. But the average consumer of legal services does not need a constitutional lawyer. What they need is someone who's going to be able to solve the family law problem they have or the criminal law problem they have. And so I would try to design a law school that would try to focus on that and get graduates ready for practice in what is an ever-changing world out there.
Thank you, Tom. I would like to go now to Professor Swan. Can you explain what, to your opinion, law schools are missing by not looking more closely at practice?
Let me offer some observations on that point. There are 151 articles, comments, book reviews, and book notes in the volumes of the Osgoode Hall Law Journal that I could find online. Of those 151, 7 deal with private law. Now, you could qualify some of my categorization as private law. There might be 10. That's around about 5 to 7%. I think that law schools are missing a huge amount by ignoring a huge chunk of what lawyers do, what society needs us to do, which is deal with private law. I'm a private lawyer, I'm a common lawyer. I practice mainly in a corporate commercial environment. I published widely in contracts. And I think that, reflected even in this program you have here, I don't think any of your sessions are focused on private law. I can't see an indication in any of the theses that I assume the graduate students are doing that look to be focused on private law. Private law meaning essentially the common law of contracts, torts, and property, restitution, corporations, and so on. I was told, for example, by a professor at a very good law school last fall that the qualification for teaching corporate law in his university is neither a law degree, no experience in practice, but a PhD in economics. I think the law and economics movement has done immeasurable harm to legal education. I think it is built on a foundation of sand. I think it's almost nothing to contribute to analysis of many aspects of private law. I think it's a bad mistake. I think it's very sad when, for example, Professor Trebilco, in his work on freedom of contract, says that, well, Ian McNeill's theory of what contracts look like, namely relational contracts, may be more accurate, but I can't talk about it because it doesn't lead to results, economically justifiable results. Well, that strikes me as being an admission of the utter poverty of economic analysis and not the inaccuracy of Ian McNeill's approach to understanding contractual relations. It's no good, law professors, in deprecating private practice and private law in particular, because you reflect upon it, this is how we get fed. If business didn't produce food, didn't provide jobs, didn't provide the things we need, we wouldn't have those things. And they do those things almost always through the organization of private law. They do it through corporations, partnerships, and so on. Among interesting things that I think students miss, and I've seen this vividly in the last 2 years in which I've taught, it's called Advanced Contracts or a Contracts 2 course. In my mind, that's a misnomer. There's no contracts course that's more advanced than first-year contracts. Second-year contracts can only be going over the first stuff again. I justify that on the basis that I teach it now from the point of view of a solicitor. And my students are absolutely terrified. Sean was in my class, and that's why I got here, because I had long, interesting conversations on the way home. But they have no idea how, for example, the first assignment I give them is to draft a dog walking contract. I say to them, you've taken contracts, you've taken torts. That's all you need to know. Now draft the contract. Well, they go on the internet and they get a dog walking contract. And that one tells them that each party should, this particular version that several students got, should require the other person, tells the origin of the contract, provide to the other his or her social security number. Why would you do that? Haven't you thought of PIPEDA and the problems of getting information that's highly confidential? One of the forms required you to make sure your address is one where service can be made upon you. Is that a good way to start off a contractual relation? In any case, they have no idea how to put a contract together. Yes, they've been taught about conditions in their contracts courses, but conditions there are purely things that the courts worry about whether they can be waived or not how they are an important building block of a contractual relation. And every year, and I've taught at Osgoode now for, I guess this is my 10th year I've taught there, The hardest thing I find in my students to understand is to understand the role of a condition in a contract. Doesn't sound like rocket science, but believe me, students when they come out of first-year contracts have no idea what a condition is in terms of constructing a relation or a transaction which will work. Secondly, one of the most important aspects of giving advice to clients in a contractual relation, particularly a long-term one, is the concept that I call role integrity. Role integrity is a thing we see in relation to fiduciary relations, principal and agent, solicitor and client. But what about it in the context of a joint venture? Yes, a joint venture as a corporation will have that through the board of directors or a partnership. What about a purely contractual joint venture? What about outsourcing agreement? Remember that the law says you can't enforce agreements to agree. So therefore you cannot have a clause that says we'll agree how we're going to deal with this. You have to have a solution that says we can't just agree to it in the future. There must be a mechanism now we can force a solution. Really interesting structures that lawyers develop, solicitors, not barristers, solicitors develop to how these things are going to work. So far as I can tell, the law school doesn't talk about these at all, certainly on the contracts course. The principal job of a lawyer in practice with contracts, apart from drafting it, is often just keeping the parties from losing their heads. Yes, the other side didn't do what they should have done, but don't go rushing off to sue. Maybe we can sort this out by making some accommodations. There's a huge tolerance, most of businessmen, mostly for, I'll call them, forced errors. If the other side says, I'm really sorry, this has happened, I can't do this, okay, make it up. Law schools, lawyers, academics and contracts go ballistic over doctrine of consideration. Oh, no, we can't enforce contracts that modify existing contracts. Why not? No consideration. It happens all the time in practice. And businessmen or clients are appalled to think, I've got to put this under seal? Utterly ridiculous. And yet, wretched people go out there and they publish these articles saying we can't have this stuff, dreadful stuff. And it's complete nonsense. Then there's the ethical dimension of negotiating contracts. What do you do if the other side sends an agreement and there's clearly a mistake? Do you lie low and wait to say later on, ha, fooled you? Well, if you did, you'd be giving your client dreadfully bad advice, because of course they're going to say, don't you dare do that. You must come up now and tell the person they made a mistake, or you certainly can't rely on the mistake that they made. And there's a whole ethical dimension to this whole business, and there's N cases. Again, I don't think the cases, certainly the case books I've looked at, do anything about that. The other thing that I can't say it annoys me, in this case I'm conscious of trying to remove the mote from somebody's eye of the beam in my own. I think that, particularly in talking about contracts, case books should tell a story. They don't tell cases, case after case after case. Very often, 1950 cases, we've all read the damn things. But what are the problems we're trying to solve? What are the solutions we have to these problems? This case is an example of a solution to the problem. Is it a good solution or a bad solution? And why do we think one or the other? Does the next case then perhaps offer a different solution? And so if you look at my own book tries not to do this, but if you look at the traditional contract case books, they don't give students any idea of how the thing actually works in practice. And I'll make an entirely tendentious comment by saying I think that law schools should teach students ultimately, fundamentally, how to give good advice to their clients when they become lawyers. Nothing else is important. This does not mean that law schools have to be nothing but trade schools, but it does mean that they have to focus on responsibilities their students will have in practice. And I think that one of the major problems of the law schools, and if I may say so, this conference, is that it focuses on things that are not at the heart of the practice of the vast bulk of the solicitors and lawyers in this province. That is, doing solicitors' work, keeping people out of trouble, drafting agreements, advising them on how to make things work, and generally making the world go more smoothly.
Thank you, Angela. So I want to go now to Dean Susin. Now, it seems that the divide that Tom talked about between the academy and the practice is quite apparent in our discussion. And it seems that law schools are a bit under attack here, to use this word, and we haven't heard Laurie yet. So, but I would like to hear from you. How do you see the things that Tom and Angela refer to in terms of the practice that should be taught in law school and not other things that are currently taught? And also, if you were part of the Law Society, how would you dealt with this?
No, that's an easy question. Shouldn't take more than a minute. And of course, I appreciate the comments that have come, and I'm always, when on these kinds of panels, focused on hearing how not just the law schools are perceived, but understanding, the different views on the aspirations that we ought to have. And I think that legal education is always aspirational. And I suppose in that aspirational sense, what I reject both from when I hear it in academic circles and when I hear it in the profession, is the idea that these are juxtaposed aspirations, that either you want to prepare graduates for practice, give them the ability to solve problems, advise clients, or you're giving them this detached academic, ideas-focused education that's like a graduate school in law rather than professional education. And I'm a firm believer in the idea that you can and should do both. In fact, I think in my own career, both in practice and the academy, I found my legal education has been something I draw on in those settings. And it's fair to say that the Osgoode Hall Law School I went to 20 years ago this year, so I'm rapidly aging in that respect. It was good preparation, but nothing like the Osgoode Hall Law School of today. And I'd say what I see in many law schools, particularly here, is a coming full circle. In other words, coming from a position of being embedded in the profession, focused on preparing lawyers, leading to understandable tensions around the goal of university-based legal education, so that then when they broke free, they so broke free that you couldn't imagine less of a conversation, as Tom highlighted, because the desire was to prove that we are not under the thumb. The regulators, Law Society was so happy to be rid of them that it had a hands-off approach for many, many years, and now we're paying the price for that lack of engagement, for that lack of an ability to walk in each other's shoes. And I think what we're witnessing now is a coming full circle back to a place where legal education is focused on experiential learning, focused on problem solving, focused on these kinds of clinical, intensive, in and out of the community and the classroom settings that enriches both the intellectual depth of legal education and, of course, the readiness of graduates to practice. So again, I put the caveat that's aspirational. It's not that every student is experiencing it in exactly that way, but I think that's fair to say what we're aiming for here. But if I'm the regulator, I think the other side of the coin is to ask myself both where is the complementarity, where are the differences between what university-based legal education can provide and what a regulator can provide, and then what can each do to facilitate the other's aspirations. So in terms of the complementarity, an obvious example is something like interdisciplinary study. Legal education from a regulator's point of view is preparing competent lawyers. So whether you have law and literature, law and engineering, whether you're looking at the intersection of environmental studies and law, from a regulator's point of view just seems like often accessorizing or luxury items that aren't part of what's essential. Whereas from the university point of view, we would see that as an integral aspect of legal education that we would be very impoverished without. I think that's a great example of a worthwhile and necessary conversation. And it's happening to some extent now as law societies and the Federation in Canada are getting more involved in the curriculum and asking, what do we do with that program of law and engineering? Is it really law in the sense that we understand the training, or is it something that doesn't count for our purposes? We're focused on the property, torts, and contract. And I think that is a very healthy, tension-filled conversation that ought to happen, and happen with real open ears and open hearts on both sides. So the last thing I'd say, and this is where the regulator, it's not just can you do good things, but also a do no harm principle, because when you tend to regulate, and this is true across the professions, the danger is that you drive people who are being regulated to sameness. Right? You want minimum standards, you want coherence and consistency, and so the worry is that we end up with law schools that are simply vague facsimiles of each other, because all of them have roughly the same curriculum and roughly the same looking program. There's lots of differences around the fringes, but I think that is something that isn't necessary or inherent in the regulatory project. The Law Society, in other words, can also be a catalyst for innovation. It can be an incubator and partner for new ideas. The most obvious example of this is part-time legal education in the province. We are the only jurisdiction I can think of with the need that is completely unaddressed for people who want a legal education and don't want or can't give up their job or family commitments to get one. Almost every law school perceives a part-time program, leaving aside graduate education, in which part-time LLMs flourish, here certainly. But for the JD program, it's typically seen as an accommodation if you can't manage the full-time program. And even then, it's after you've done a full-time first year, which is seen as this integrated whole. That's a great place where the regulator can say, how can we help develop something that would meet the needs of enriching the profession, providing more accessibility to it, and also be something that has a progressive element to broadening the reach of the legal profession to areas now where it is very much underrepresented. So I would say, you know, again, to conclude, view these as complementarity-oriented relationships, mutually enhancing, not a zero sum, that to the extent you see it as training lawyers to serve clients, you're in any way diminishing the intellectual richness or vice versa. See the regulatory relationship as a catalyst for innovation rather than a driver to sameness. And lastly, I think coming back to Tom's point, is take seriously the need to walk in each other's shoes. You know, should we have a faculty member seconded to the Law Society to work on projects? Should there be a bencher whose role it is to be assigned a law school and get to know it, get to understand what makes it tick, and be able to communicate that out to colleagues? And certainly in other Canadian jurisdictions where there's only one law school, the dean of that law school is simply on as of right the leadership of the Law Society with that very thought in mind. And here again, I think we suffer for the lack of that sense of mutual understanding. So let me finish on that point.
Thank you, Lauren. So last but not least, Laurie, Tom touched upon the challenges of the 21st century in terms of legal education. And I would like you to refer to the regulatory challenges that you see in the 21st century in the context of legal education. And also, it seems to me that Tom made a judgmental remark regarding the changes in the UK. So if you can also refer to this point.
It's always the problem with speaking last, all the great ideas you had. So, as the regulator, we regulate the provision of legal services. But the way that our structure works, of course, in Canada, is that this is all done by geographic boundary. And so the Law Society of Nunavut exists and regulate the people who provide legal services within their geographic boundary. We, Upper Canada, no longer exists, but we regulate the people who provide legal services. And I say legal services because, of course, we regulate not just lawyers, but independent paralegals who provide services within a narrow scope of practice in Ontario. So the role of the regulator across the country, the independent regulator, is to regulate competence, of course, conduct, and in Ontario, we also have an obligation to facilitate access to justice. We regulate individuals, not structures, not law firms, not corporations that are, generally speaking, not corporations that are providing legal services. So that puts us in a position where our structure, I think, is not as responsive as it needs to be, given what is happening globally and across the country. So what I mean by that are a couple of things. First of all, of course, we now know that what legal services at least low and middle income Ontarians need. So when we have started to look at access to justice, we as the regulator who have that obligation to facilitate, we know now, thanks in large part to Lauren's participation in the Ontario Civil Legal Needs Report, that 1 in 3 low and middle income Ontarians have a civil legal problem, have had a civil legal problem in the last 3 years. And by low to middle, it's household incomes from $0 to $75,000, right? 30% of those people have had a family law problem in that time frame. 19% a housing issue. 13% a wills and estate issue. 9% an employment issue. Of those, the respondents said they would like to resolve the legal issue they had with some legal help, but they don't want to give over the resolution of their legal issue entirely to a third party. Of the ones surveyed, 73% of them spent some money on legal assistance, a lawyer, it seems. And how do they come to find assistance to resolve their problem? 41% turned to a lawyer, 31% turned to family and friends, 27% turned to the internet. That's in 2009. I suspect the percentage would be much higher now. And of those, 84%, low and middle income in 2009 had access to the internet. So it's no surprise that if you actually then look online, I don't know, has anybody been online and seen LegalZoom? More than I thought, that's good. The rest of you must. Google LegalZoom. For $299, you will fill out a form. You will get documents, both sides. You'll get for an uncontested divorce. You will get a property agreement. You will get child support calculations. You will get all of these things spit out and back to you, delivered in 5 to 7 days, right? For your uncontested divorce and all the accoutrements for $299. All designed, focused on the relevant state, wherever you reside. And they do it for both spouses. So the documents they produce, boop, for both spouses. QualitySolicitors.com. Anybody know about QualitySolicitors.com? They're even more interesting. They've had a $16 million investment, and they have a huge advertising campaign, TV, internet, and so on and so forth. They provide that you go online, fill out a questionnaire, or call somebody, and you have a 15-minute call. They take down information. They promise you 45 minutes of free legal advice from a lawyer, generally responding to the questions that you've asked, right, or the question that you've posed in your questionnaire. They have legal guides online for personal injury, for real estate, for wills, for estates, for all of the usual problems. They have commoditized the service, and they have legal access points where you can speak to your friendly quality solicitor's advisor at the W.H. Smith store. And they have picked and given a brand of quality solicitors to solicitors firms all over the UK. And they have a cartoon character, a woman, actually, interestingly enough, in a pinstripe suit. And she's the one that, you know, she's the face of quality solicitors. OzPropertyLaw.com. You go online, you never meet a lawyer, you never meet a conveyancer. You plug in the address of your property, you say, I'm transferring, I'm selling or buying. Right? You'll sign up. They will transfer your property anywhere in Australia, and you never have to walk into an office. So, contrast that with where regulation is, which is we regulate the services that are provided within our geographic boundaries. Well,
By human beings.
by human beings, right? That ship has sailed. And how do we provide legal services now? Well, it's very clear that we are providing legal services. We, the royal we, the global community, is beginning to provide legal services in a way that we have never provided legal services before. Nobody needs to come and see me. Nobody needs to come into my office. Most people, to the extent that they have basic legal services, clearly they want to resolve issues themselves. They have access to the internet, and people are commoditizing services. Businesses are commoditizing the services that people need. So, you know, as the regulator, from my perspective, we are on the edge of a precipice, clinging to a method of regulation that no longer represents the way in which legal services are provided. And the way that the kinds of legal services that lawyers still provide do not appear to be what most people need or want, right? Which is why people go to LegalZoom, right? Because they can resolve the legal issue themselves with some legal help. They actually, you know, believe that all of the information they can manage well enough so that they don't need professional assistance, or if they do, they don't need much. So the way in which, and you know, we regulate obviously, and the way in which a legal education then provides a grounding for this brave new world is something that I have no answers for. I can only tell you about the challenges, and I can only tell you that, thank the Lord, my term as head of the Law Society is up on June the 28th, and Tom Conway's taking over.
Thank you, Laurie. Dean Cameron, do you want to comment? We need to make those comments more briefer than we done so far. So if you want to comment.
Okay, I can do that. I'll take a Twitter approach. First of all, Tom's comments. I'm not sure I think the disconnect is quite as extreme as he suggests, but I understand he was sort of perhaps exaggerating just a little bit to make his point. I think the disconnect he speaks of is more or less of an issue depending upon how we define what lawyers do. Okay, I'll leave to one side whether it's realistic to think that they can be practice ready after 3 years. I have my own views on that. And as someone who went into practice after law school with a great education and with lots of skills, I wasn't practice ready, and I don't blame that on the law school. I attribute it to the nature of the task. But leave that to one side. I think law schools do have to think about the emerging landscape that various people here have talked about. and so does the regulator. And one of the ways the regulator can think about that is to think about what practice means, okay? And therefore what practice ready means, and what are we training lawyers for? And a lot of us have talked about that today. Professor Swan, anybody who takes a shot at law and economics is in my good books. I do think there's a bit of poverty involved in it, and I do think that for complex human problems, sometimes it is extremely limited. So I just have to say that. Maybe I'm not quite as against it as she is, but I sympathize. I think what Professor Swan makes is a plea for an integrated curriculum, a curriculum that doesn't construct subjects in silos, and that thinks about knowledge, skills, and attitudes, and that understands that any good curriculum has to reflect all of those, not at different times and in discrete sections, but more or less at the same time. I agree with Lauren that there is room for difference, and there has to be room for difference amongst law schools. Laurie's comments resonate, and the question, as soon as she started talking, I wrote was, who is the regulator and what are they regulating? And really, I think that's what you're talking about, and that's the key question. So I think defining competencies is a key issue if we're going to make people practice ready, whatever that means. And defining competencies, it can't just be the regulator, it can't just be law schools, it can't just be a partnership between those two, but it has to be them. I think what Laurie's comments indicate is that there are other people in this complex world involved in thinking about legal services and the role of lawyers. And so the debate around what practice ready means has to include more people than just law schools and the regulator. And it has to include a regulator that has, I think, an enhanced view or perhaps a richer concept of what exactly is being regulated.
Thank you. Tom, do you want to comment on the other panelists?
Well, I think I was struck by Laurie's comments about LegalZoom and so on, and you're seeing legal services being delivered by over the internet, and is the proposition, and again to the question of who's the regulator and what are we regulating, those are legal services that are being provided in Ontario from someplace else by people we don't know and have never seen before, and what is the lawyer's role in that? Is there a lawyer involved in that at all? It seems to me that those legal services are being delivered by an entity that is not an individual, and they are delivering legal services, with skills that we don't teach in law schools, and we don't teach in any practical or experiential training that we do of lawyers presently. These are legal services that are being developed, that are being delivered by software developers. And what is the lawyer's role in that? But I mean, they're delivering a product that's competitive. I mean, $300 and you get your problem solved. I mean, that's extraordinary, and that's not something that you can do if the medical profession can't replicate that environment, because the fact is you got to have a body, and you're going to be poking at a body. I mean, that's what they do. So. What we have traditionally provided in terms of legal services is very different from the kinds of services or the kinds of things that other professions deliver. So it is an amazing world that we're in now, and I think the Academy and the regulators have a lot of thinking to do about this, about these challenges.
Thank you. Angela, do you want to comment?
I guess what I'd say, I mean, I agree with what Lauren was saying, that obviously, I don't want people to take my view as kind of guessing how to organize a law school, just to point out one particular aspect of where I think legal education could greatly enrich the experiences students have. And I think that part of the problem, and I noticed as I reread the author's report recently, just in preparation for this, which is a dreadful document. And what it did was it both misunderstood what practice looks like, and misunderstood what good legal education does. Written by somebody never taken a law degree, I think. But the thing I would worry about, for example, it wasn't touched by Laurie, but one of the things that keeps lawyers awake at night is worrying about conflicts of interest. So a client phones me up and says, I got to then do a conflict search. And the plain fact is that in any firm, my firm is not that big, it's 130 lawyers, you can't actually function the way the Law Society's rules require you to function with respect to conflicts of interest. It's just not possible. We have, I don't know how many hundreds of firewalls we have in the firm, but until we approach that aspect of regulation, then we can't begin to break down some of the things, because I've had to turn down simple requests from people I'd like to do pro bono work for because I can't act for them because I can't clear a conflict to the satisfaction of our conflicts committee. But I'm only giving somebody advice that might take me 15 minutes. I just can't do it because if I were to do it and a client were to find out, then all hell breaks loose. I think those are kind of the institutional constraints on breaking down some of the things that into more manageable chunks that we do.
Thank you. Lauren?
Yeah, just briefly, I want to say in response to the really, compelling and for many scary thoughts on the disruptive effect of technology and moving past jurisdictions and the anonymity of that advice and all the other concerns, there is a similar disruptive moment going on, of course, in university education and legal education included, as material from courses and online degrees and the open access allows potentially people to get an entire legal education without stepping into a classroom or having a face-to-face real-time interaction with a faculty member or the kinds of experiences that we would say constitute law school. And we've got to get, we have to get our head around that in terms of what gets built into our programs, how we approach those entities that are offering those kinds of legal education, online and in asynchronous ways. And of course, the regulator has to figure out, will people coming out with that education be eligible to practice in one way or the other? So I think that kind of disruptive moment does require us to ask the big questions. What is legal education? What are the knowledge-based competencies, skills, experiences that one needs? And I think whenever we buck a trend of where choice and preference goes in the market, we are largely fighting a losing battle. And I think that's, in other words, to say, people want this and need this, but we're going to do everything we can to make sure they can't get access to it, strikes me as a losing battle, and yet one, if you ask people their initial instincts, that everyone is running to the barricades to fight. Right? How do we keep the online providers out? How do we raise the barriers of entry for new programs that build in those components? And so, I think this is going to be not just for the regulator, but for the law schools, the question coming. And again, I fall back on what may be an overly naive, maybe I'll join Tom in the naive camp, overly optimistic and naive view that you can have the best of both worlds. You can keep quality and rigor and richness and embrace new forms of delivery in hybrid and innovative ways, so as not to create this either-or dichotomy that we tend to too easily fall into.
Thank you, Lauren. Laurie?
I think the only thing I'd like to add is that I think the beauty of what has happened from a technological point of view is that it has demystified this knowledge that we have always clung to and used in the profession, and so which is a good thing because people realize that some aspects of law they can research on their own, they can understand the issue perhaps a little bit better. Then the question becomes, of course, well, what is the role for the legal professional? And the role for the legal professional at a certain point has to be taking something from the information and actually being able to apply it in a way that is useful and relevant to that person's individual circumstances. And that's often what we see with self-represented people that they have lots of information, but they have no idea how it applies in their circumstances. So if we assume that there's still a role for the legal professional, then how is it we assess their competency in that role? And the only thing that I will say is I strongly am of the view that we will be seeing more periodic testing or checks on competence as people move through the process. So I think we will probably see the end of simply testing competence at entry level and then just leaving people to fly on their own forever. In the UK, they're just introducing now in the criminal court system a sort of graduated license for people. So how we are going to assess people's competence, but we do know that it's a continuum. Law is experiential, and and you get better at providing advice as you go along. I think there still will be a role for the legal professional. I think it's going to be for the regulator. We will be playing a different role, both with the individual as well as with the way in which services are delivered and regulating those services over the internet.
Thank you, Laurie. We are going to have now a short session of questions. If someone want to ask one of the panelists a question, feel free. Yes, Cyrus, please. I'll repeat the question for the recording, but go ahead.
My name is Cyrus. I enjoyed a lot of the discussion. But just, here's the one problem, big problem. Legal education, that is justification, nationalization and legalization, all injustice in our society and the law schools, such as wage slavery, prostitution, sexism. For example, just, minimum wage in Ontario. How much? It's $10, right? But how much a law professor and prosecutor? Minimum more than $100,000, some of them more than $200,000 plus social advantages. How much we have $50? So why with this kind of thing they want to teach us because it's law and we have to obey the law because it's legal education? Question. You do not touch the injustice by legal education.
Cyrus, do you want to approach this question to a specific panelist, or do you want general? Okay. Lauren, do you want to?
Sure. So the question, just in case it didn't get captured, was isn't there a disconnect between the injustice that many people will see around them, that law is not a force of good, but in fact, an integral element of these inequalities and oppression that we see around us, and is legal education focused on this sort of ideological project to convey the idea that law equals justice and is good? And I think by response, I'd say the part of the move to university-based legal education has been all about ensuring the critical perspectives. And I'd say in a lot of settings, and I can think of a few that jump to mind, the only place where you see meaningful critique of the role of law is coming out of those institutions, which are publicly funded and have a public mandate. And I think that's been a long-standing tradition, certainly at the two law schools represented here today at Windsor and Osgoode. And it's taken very much to heart. In other words, even though we're government funded, you'll see projects that are highly critical of legislation and the role of government decision-making. Even though we are in rooms donated by philanthropists, you'll see critiques of how, Neil Brooks comes to mind, and the trouble with billionaires, on how the tax system subsidizes wealthy individuals to leverage their funding into influence in universities. So I think it's a fair concern to raise, but I think the evidence bears out no shortage of seeing law as a critical project. And I always start off courses that I teach by saying there's two things you need to come out of this class with: an understanding of what the law is, and this goes to Tom and Angela's point that if you're going to be advising clients or a legal professional, it's critical that you know what the law is. But we wouldn't be finished our class if you didn't also have a sense of what the law ought to be. in this area, which includes that critical project. And if we're doing one and not both, I would say we're letting down our students. Also, I'd say if we're doing only what law ought to be and not conveying a clear and usable foundation of what the law is, we're also letting down our students.
Tom, you want to also comment?
Just a very, very brief comment. I think that we, as the regulator and the law schools, have done a fairly poor job in the last little while in educating, during the formation of lawyers, educating lawyers about what their obligations are as lawyers in what is ultimately a social profession. That we have, that our codes of ethics, that our values as a profession require us to address injustices and to try and help those that have real needs. So, for example, when I started practicing in my law firm years and years ago, the law firm I was at the time, there were criminal law practices, criminal defense practices, there were family law practices, there were immigration practices, working hand in glove with corporate practices and real estate practices and so on, where the money was. And it was just considered to be something that a firm did all of these things. But as the profession started becoming more corporatized and influenced by corporate trends, it was realized that the return to the shareholders, the equity partners, wasn't as great if the firm continued to practice in areas that were not profitable. And so you would have to go a long, long way in 2012 to find a law firm that actually does all of those things. And what you've seen happen, I think, over the years is law school, smaller practices, like in the criminal defense area, in family law area, they are, if they're not doing the so-called carriage trade, the high-end income earners, they're not surviving because they're not, because there's, you can't feed your family off of what a legal aid certificate will pay. So, you go to any of the downtown law firms in Toronto, you're not going to see them doing those practices anymore. And I think that's because we have failed in the way we educate lawyers and the way we regulate lawyers, to remind them that this is not just something they should do, it's something that they must do. If we're going to really, because that really is the only thing that distinguishes us as professionals, in my view, from LegalZoom or Legal Oz, or that they're really just about delivering a service.
And Tom, do you think that the Law Society should actually operate in this level?
You mean in trying to?
Yes.
I personally, I believe it should. Not sure I'm going to be able to carry many benches with me on that, but we'll see. I think access to justice and trying to address those issues in a real concrete way is something that everyone at the Law Society that has been elected is very much in tune about. But there are competing concerns as well, and that is that we're living in an economy that is extremely difficult right now, and you've got, obviously folks are concerned about the amount of money that the members have to pay, so there are other competing interests. But I think there is an awareness. Certainly, when we talk about the common law degree now, there is a requirement that all common law graduates have had to have taken a course in ethics and professionalism, and we amended the requirements or the content of those courses to include the obligation of lawyers to provide access to justice, which had not been in the first round. So, in small ways we're addressing it, but.
Okay, so we can take one last question. Yes, Alan. Go ahead. Yeah.
My name is Joe. My question has to do with legal education. And I was wondering if the seminar, every day is about a problem, and they have to research it, discuss it, solve the problem. They take academic sessions, and then after a certain number of weeks of academic sessions, they are put into a clinical situation in actual practice somewhere with testers in which they use what they learned during that session. They then come back with another number of weeks of academic session, and another clinical station. You sort of get through not only out of sitting in the lectures to learn what you're doing, but you get some of the actual practical experience of how to do the profession. Has that ever come up as a possibility?
Yes, Dean Cameron, please.
Yes, it has. And I can tell you, I'll give you one example from my personal experience. I spent some time teaching in Hong Kong in the 1990s, and the program I was teaching in used the problem-based learning model. Similar, not identical to the McMaster model, I'm familiar with that one, but quite similar to it. So yes, other law schools have used it. It's certainly been considered. I think I can tell you now that if we were to try to implement it in many Canadian universities, we would quickly conclude that we can't afford it. It is a more expensive model for various reasons, which I won't go into. So the short answer to your question is yes, various law schools have tried it. Some in the US have tried it as well. And yes, it does work. I think it's a good model, I agree with you. The university I just left, the medical school used it there as well. The resources they needed to make it work would boggle your mind. And they were a lot richer than the law faculty was in that university. So yes, there's a cost issue, but yes.
Yes, Angela, you wanted to comment?
There's one interesting problem that I encountered years ago. The author's report said that you should do law with somebody else. Law by itself was no good. But you encounter a serious problem. You can take, I went down, I wanted to figure out if my ideas of contract actually worked in practice. So I went to a major downtown law firm for the summer just to explore it. Now, I could do that because I was a member of the Law Society, but the firm would not let anybody else get access to the client's files, talk to the clients, because they're not bound by the same obligations that bind me. And so you cannot expose a lot of the work goes on in firms to people who are not yet members of the profession. Now, we do it with students because they're part of the profession in that sense. They're under the jurisdiction of the Law Society. But clients will not accept exposing their information to people who are not bound by the rules that bind all lawyers. So you have an institutional problem there, because lawyers take very seriously the rules of professional conduct and what they can, and the obligation to keep clients' information confidential.
Lauren, do you want to?
Yeah, no, just briefly to Camille's point, which is absolutely right, that I think it's widely shared as a kind of best practice of pedagogy, but it's a more expensive model. But I think there is some important steps forward. So collectively, here at Osgoode, as many in the room will know, we've moved to a curriculum that will require at least one experiential course or seminar for every single student. Now, what that builds in is a taste of that kind of problem-solving model. So it can be a clinic, it can be an intensive program, and certainly that's how the clinical models work. You're in a seminar, then you're doing the work, then you're reflecting on it afterwards, and that can happen all in-house, it can happen in the community, and it can happen in a hybrid way. And we've got models across the board in that respect. But each one, let's say, is to make it work, is usually about 10 or 12 students, has a faculty member engaged in close to half that faculty member's teaching load, and an external partner. We've added together enough of those to ensure that for a class of close to 300 students a year, every single student will have that experience before they graduate. But that's been an enormous resource focus, and it's had to also collectively engage the whole community, alumni, students, faculty, that's the direction we want to chart, and we will spend the resources on that, obviously to the exclusion of other things, because their resources are always scarce. So the idea of building the entire program around that model, I think, is not where any school is at, but I think moving in this direction is important. And I come back to the role of the regulator to be a catalyst, to say if the Law Society thinks that it would like to see itself play a more involved and constructive role in legal education, that's a perfect area for it to be a partner in, especially in Ontario with not having a bar admission course anymore. That extra role of the Law Society providing educational resources, it will wither unless there is a move to say, well, we're the regulator and not the educator. We can be a partner in making that happen. So I hope, again, that's an area where the dialogue will lead to moving forward together.
Do you want to add anything?
10 seconds.
Sure.
Almost every law school in Canada, 85%, do some version of what Lauren was just talking about. And I'd hate us to go away today thinking that law schools haven't evolved in that way over the decades.
Yeah, fair enough.
What they are doing in clinical and experiential learning and the time they are spending on it is really quite commendable. And it might be not be that pure problem-based learning model that some medical schools have adopted holus bolus. But if you look at what law schools have, how they've changed over the past 20 years in terms of integrating experiential learning into the curriculum, you'd have to be impressed.
Thank you. So I would like to thank our panelists for coming here today. Thank you very much. And for a fascinating discussion. So we'll take a 15 minutes break and we'll adjourn here at 11:45. There's coffee and juice in the JCR at the end of the corridor, and I'll see you all in 15 minutes. Thank you.